Good morning, everyone. Thank you so much for joining us for the 7th webinar in the 2021 Workforce and Retention Webinar Series, brought to you by South Carolina Department of Commerce. And today we will hear from the U.S. Department of Labor, Wage and Hour Division. My name is Sonia Barkley, and I am your moderator for today. I am also the Small Business Outreach Manager, and just wanted to go over a few housekeeping rules for the webinar today and let you know that it is being recorded. All participants are muted and cameras are off, and we ask that you use the chat feature to submit your questions, and they will be answered at the end of the presentation. The webinar is being recorded. You will get that recording along with slides and any other information, and it will be sent to you by email. And you'll also receive a survey at the end with just 3 short questions, just 2 yes or no, and 1 just asking to list a topic that's important to you. So we can continue with a different type of webinar series, possibly based on your feedback. So why is Commerce doing this? And why are we here today? Well, earlier this year, over 2,000 companies received a Commerce survey to get some feedback about connections made to help their businesses. We wanted to know if they received the help that they needed from those connections and what was the impact of those connections on their business. Business owners were also asked to identify the 3 most important strategic opportunities or challenges that they had with their company, and employee recruitment and retention was number 1. So here we are today, and monthly webinars that we've been running from June, and it'll run through December, and they'll highlight additional workforce resources and options that you have as business owners. Today's webinar is our 7th in the series, and in a few minutes, we will hear from Colin Trimble of U.S. Department of Labor. Just want to thank everyone for joining us today and welcome. Before we hear from Colin, before he begins his presentation, let's take a look at who is here today. On this slide right here, this is a chart that gives you a snapshot of all industries represented today, and it also tells the story of how South Carolina businesses share some of the same needs and concerns when it comes to workforce and retention. You can see from the chart that manufacturing, marketing, and even staffing agencies all share the same challenges to some degree. Now, your go-to for your staffing needs, it's still workforce development, it's still SC-Do and SC Works and all other programs that offer workforce and retention support. This webinar series was designed to introduce other workforce or staffing options that may be unfamiliar to you. Today, we are offering an educational component to the series, and Colin is here today to talk about essential workers and essential protections. But first, let me tell you a little bit about Colin. So Mr. Trimble is the U.S. Department of Labor Wage and Hour Division's Community Outreach and Resource Planning Specialist in the Columbia District Office, which covers all of South Carolina. In this role, he builds and maintains relationships with stakeholders in the regulated community and with organizations representing workers affected by the federal labor laws enforced by the Wage and Hour Division. Colin is eager to provide compliance assistance and employee rights information throughout South Carolina. Colin was a wage and hour investigator in Ohio from 2010 through 2018. And prior to joining the U.S. Department of Labor, he was a Peace Corps volunteer and worked in financial services. He's earned his Bachelor of Business Administration degree from Ohio University and also a Master's of Business Administration degree from John Carroll University in 2014. Colin is up next, and I encourage you to ask questions. Remember to use the chat box, and later maybe make an appointment to speak with him if you have other questions or things that are specific to your business needs. At this time, we will hear from Mr. Trimble of the U.S. Department of Labor.
Thank you, Sonia, for that introduction, and thank you to the South Carolina Department of Commerce for the invitation, and thanks to you all for joining us this morning. I'll go ahead and share my screen so you can see the presentation I'm going to share with you today. Just a second. Is the presentation visible on your side, Sonia?
It is.
Okay.
Just need the full screen.
Okay. So now we're in presentation mode. Is that working, or slideshow mode?
It's good now.
Okay, perfect. So as Sonia said, I'm going to be sharing a presentation that we call Essential Workers, Essential Protections. And this is from the U.S. Department of Labor Wage and Hour Division. We're a federal agency and we enforce federal labor law. Two of the laws I'm going to be talking about most today are the Fair Labor Standards Act and the Family and Medical Leave Act. Here you can see on this slide, and I think on most or all of the slides today, you'll see our agency's web address and toll-free number on the bottom right of your screen. So with that being said, I'll go ahead and get started and jump into the presentation. So the laws that we enforce, Fair Labor Standards Act, Family Medical Leave Act, among others, affect a lot of people. And it's estimated that about 10 million establishments nationwide are covered. And that means about 148 million workers are covered across the country. We have about 200 offices throughout the country. As Sonia said, mine is the Columbia, South Carolina District Office. We cover all of South Carolina, but we have partner offices in North Carolina, Georgia, and throughout the country. So people from all across the country, regardless of language, can call us. I like to say that language should never be a burden before contacting us. You know, somebody can answer your call, and even if they may not speak your language, we have language resources within the agency so that you can have your voice heard, you can ask your questions, we can address your concerns. So, you know, we have a multilingual staff and we also have a translation service to help with that. So anybody in any language can call us, use our toll-free number or call one of our local offices across the country, and we can help whether you're a worker or an employer or an employer's representative, such as an attorney or accountant. We help all sides with their questions and concerns about the laws that we enforce and answer questions, and hope that workers understand their rights and employers and their representatives understand their responsibilities and obligations to comply with the law. So we enforce these laws without regard for immigration status. We don't enforce immigration law. We don't enforce tax law. We just enforce federal labor law, basically wage and hour law. So, you know, OSHA is our sister agency and they enforce a lot of the safety and health aspects of federal labor law. We enforce the wage and hour aspects of federal labor law. And so we don't ask workers about their immigration status during the investigations or when we receive complaints, because again, we don't enforce immigration law, tax law, or anything else, just wage and hour law at the federal level. So here you can see a representation of our offices across the country, all the little dots there. And we're divided into 5 different regions. South Carolina, of course, is part of the Southeast region. And so we work in partnership with different offices around the Southeast when it comes to enforcement and outreach and partnerships that may cross state lines. So here you can see a representation of that, and just it shows our reach across the country. And there, our toll-free number is there as well for anybody to call in any of the 50 states or US territories if they have any questions about the laws we enforce. Here you can see a representation of the kind of help we've delivered over the last 5 years. I think this information might go through fiscal year 2019 or fiscal year 2020, I think it was. So it's a little bit outdated, but it just shows what we did in a 5-year period, helped over 1.3 million workers enforcing these laws, and we obtained more than $1.4 billion in back wages for workers in that 5-year period leading up to the end of fiscal year 2020. And so how do we do that? We have various ways to achieve our mission and achieve compliance across the country. First and foremost, we are an enforcement agency. So a lot of our staff are investigators. I used to be an investigator for 8 years in Ohio. And so I can speak from experience when it comes to some of these laws I'm going to explain a little bit later. But now, as an outreach specialist, I do a lot of outreach to workers and provide education to employers like today's presentation. Many of you on the line are probably employers or employer representatives. And like I said, we provide education outreach to both sides because we want all sides to know what the rules are. We want workers to be aware of their rights so they can speak up or call us if they have a complaint. We want employers to know the rules and regulations so that they can comply. We know a lot of employers out there want to comply, want to do the right thing, And so we want as much voluntary compliance as we can get, because we're simply not big enough as an agency to be everywhere all the time enforcing the law. So we want employers who want to comply to know the rules, know the regulations, so that they can follow them and not have any wage and hour issues. And we also develop partnerships with state and local government agencies or other federal agencies, sometimes share information. Sometimes we do joint outreach presentations. So we have a bunch of different ways of achieving our mission. We do a lot of our investigations based on complaints, but we also do a lot of them without a complaint. We call it agency-initiated enforcement. We have data and a lot of experience enforcing these laws. And we can use that data and experience to identify the industries and geographic areas where violations might be more likely to occur. And so sometimes when we start an investigation, we have a complaint, sometimes we don't. The truth is, as investigators, it doesn't really have any bearing on how we conduct ourselves during the course of the investigation. The investigations are done the same way, with or without a complaint. And we don't divulge that information. We don't reveal whether there's a complaint or not. Complainants are confidential. The fact that there is a complaint is confidential. And so we just proceed the same way with or without a complaint. And we gather records, we interview workers, we look at the facts, apply the law and regulations. And if there are violations, there are violations. We ask employers to correct them going forward into the future, and also to pay back wages potentially for any violations that may have occurred in the period of investigation. And if there are no violations, then we close the case and move on to the next one. So it's really as simple as that. As I mentioned, we provide outreach to both sides, workers and employers and their representatives. We want workers to understand and exercise their rights, and we want employers to understand their obligations and responsibilities so that they can increase their compliance level voluntarily. And we know many employers have an interest in doing so. So we call this presentation Essential Workers, Essential Protections, because we recognize that many groups of workers have been considered essential during the pandemic. And you may have heard about them on the news: workers in agriculture, grocery stores, public transportation, restaurants, and construction. These workers are in positions where they've had to continue working during the pandemic. We want to show appreciation and recognition for that work and make sure they are aware of their rights under the laws that we enforce. Chief among them, the Fair Labor Standards Act and Family Medical Leave Act, which I'll be explaining here today. So these are the essential workers, and they are at risk for some of the violations that we commonly find on that list of industries there. Those happen to be some of the industries where we have historically found violations. And so some of the risks these workers have would be relatively low wages. You know, the federal minimum wage is $7.25 per hour. Workers in these industries may be paid at or slightly above that level. But then if you factor in issues like being told to work off the clock, or maybe they have illegal deductions for tools and materials they use on the job, or uniforms, those sorts of deductions or unrecorded, unpaid work can cut into their minimum wages and cause a minimum wage violation. It can also cause overtime violations. So those are just some of the risks that these folks are exposed to. They also, in some cases, could be misclassified as independent contractors. That has been a growing trend in recent years, unfortunately, where workers who would have traditionally been considered employees are now being classified as independent contractors simply because they're given a 1099 tax form instead of a W-2, or simply because the employer tells the worker that he or she is an independent contractor, but just saying so or giving a 1099 tax form instead of a W-2 doesn't make it the case that the worker is actually an independent contractor. There are factors that we use that have been determined by the Supreme Court over the years in different cases, and we use those factors and apply them to each case where there is a question about whether a worker is really an independent contractor, or maybe they are misclassified and could be really an employee. And so we apply those factors in those cases, and sometimes we find that an independent contractor or so-called independent contractor is really an employee and therefore is entitled to minimum wage and overtime protections or Family and Medical Leave Act protections. And those sorts of violations could be very costly to an employer. For example, if so-called independent contractors were working 50, 60 hours a week, the hours weren't being recorded, no overtime was being paid, and there were several workers in this category, then you could see how back wages for overtime could really pile up. So those are costly mistakes for an employer to make. We want to make sure that employers and their representatives understand that there is a difference between employees and independent contractors, and it's not enough to just say that somebody is an independent contractor or give them a 1099 tax form. There is a fact sheet we have, fact sheet number 13, that I would recommend all employers and their representatives to read if they have questions about this employment relationship or employee classification. How should a worker be classified? Also, essential workers may be exposed to a variety of workplace risks and hazards. If they are under the age of 18, that may bring us into play with regard to child labor rules that we enforce under the Fair Labor Standards Act, but also OSHA, our sister agency in the Department of Labor. They enforce safety and health rules for all workers, regardless of age. And so OSHA may be involved in those sorts of situations. Finally, there is denial of qualified leave. That's a risk for these essential workers. And I'm referring here to the Family and Medical Leave Act, or FMLA, as it's commonly known. That law has worker protections that provide for leave from a job for an employee's own serious health condition or serious health condition of a family member. And I'll get into FMLA more here in a few minutes, but denial of qualified leave is one type of violation that we see sometimes for these essential workers. So here's a general rundown of the essential protections that we provide in the wage and hour division under the laws that we enforce for these essential workers. Payment of minimum wages and overtime. And we also enforce youth employment standards or child labor standards. We use those two terms interchangeably, youth employment and child labor. They fall under the Fair Labor Standards Act. And then under FMLA, there are job protections for time taken for the birth of a child, adoption of a child, or caring for sick family members. We also enforce housing and transportation standards for farm workers. Housing has to be meeting certain standards in terms of being sanitary and having enough bedrooms for workers to sleep and so on. We also enforce transportation safety. We check the vehicles when we do investigations on farms to make sure that farm workers being transported by the employer involves vehicles that meet certain safety standards. We also enforce the payment of prevailing wage rates for federally funded construction and service contract work. If it's construction and there is federal funding or it's on federal property, the Davis-Bacon Act or a Davis-Bacon related act, of which there are many, would come into play. And that law requires prevailing wages, and that means a basic hourly rate plus a fringe benefit rate. And that depends on the location of the work, the geographic location of the work. The prevailing wages differ by location, but we enforce those across the country. And then if it's service contract work, typical services on federal properties or contracts that involve federal funding for services could be for janitorial services, landscaping, security guards, things like that. And that work falls under the Service Contract Act. If there is federal funding, and Service Contract Act, just like Davis-Bacon Act, has prevailing wages that involve a basic hourly rate and a fringe benefit rate that we enforce in the wage and hour division. Finally, we enforce labor standards for hiring and paying workers temporarily in the US under a few different visas: H-2A for agriculture, H-1B, which is typically for more white collar kind of work, think technology workers and so on, and H-2B visas. H-2B is for manual labor that is not agriculture. Some industries that use H-2B visas, for example, would be landscaping or certain kinds of construction and so on. Okay, so now I'll get into more of the specifics under the Fair Labor Standards Act, or FLSA. It's a law that's been around since 1938, so we have a lot of experience enforcing it. So the basics of FLSA are a minimum wage of $7.25 per hour. We recognize that different states and cities may have higher minimum wages, and that's fine. It's probably best for an employer to abide by the highest standard. That's what we recommend throughout the country. If you're in a city or a state with a higher minimum wage than $7.25, an employer should follow that to make sure that they're in compliance. Also, under the Fair Labor Standards Act, there's a requirement for overtime paid at time and a half for hours worked over 40 in a work week, not after 80 hours biweekly. That's a common mistake. It's hours over 40 in a work week. There are record keeping requirements that we enforce, also certain prohibitions against youth employment or child labor, depending on the occupation or perhaps the hours of the teenager. And then there are anti-retaliation provisions that we enforce. A complainant who files a complaint with the Wage and Hour Division cannot be retaliated against for filing that complaint. That is their right under the Fair Labor Standards Act. And workers who cooperate with us during the course of an investigation, even if they haven't filed a complaint, they may just do an interview with us. They may provide some sort of information to us, whether they've kept personal hours records or pay stubs and they share those with us. It is their right to cooperate with us in the course of an investigation, and they can't be retaliated against because of that cooperation or providing of information and so on. We see violations sometimes when it comes to hours worked. And when we say hours worked, we're talking about hours per day and per work week for the same employer. One common mistake I want to address is an employer who may have two different restaurants on opposite sides of town. There's a diner on the east side of town and a sports bar on the west side of town. And sometimes we'll see one worker doing work at both places in the same week. And an employer may make the mistake of thinking, well, this person worked 25 hours at the diner, 25 hours at the bar, and they have different names. They're registered under different LLCs. They run different payrolls. So I'm going to give that person 2 straight time checks at 25 hours each. But that would be a mistake because under the law, being in different locations, having different names on the sign out front or having different LLC names, that doesn't matter. We look at something called an enterprise concept under the law. And in this case, in this scenario, that one employer is a common owner with common control and runs these 2 restaurants for a common business purpose. We would say that this is one enterprise under the law, and therefore the worker actually did 50 hours for one employer. He or she would be due 10 hours of overtime pay. All 50 hours can't be paid at straight time. 10 of the hours, the 10 hours over 40, have to be paid at time and a half overtime. And this is true whether or not the employer counts the time as work time. Sometimes we find hours that are not recorded or paid. For example, I'll just keep the restaurant scenario going. A restaurant closes at 10 p.m., let's say, and the employer has a rule or a standard that employees should take 1 hour and no more to clean up after the closing time, time to clean up and close the restaurant and be out by 11 p.m. Well, that might be a standard, but if there is a big mess, if it was a very busy night at the restaurant and there's just a lot of cleaning to do, maybe somebody called off sick. And so one worker has to do a lot extra after closing time and stay late to do all the cleaning and so forth. That worker may stay an hour and a half or 2 hours past 10 o'clock. All of that time has to be counted and paid, even though it's longer than the employer may wish. The employee didn't get out at 11 p.m. It took them until midnight, let's say, to do the work. All the time up until midnight has to be paid. If the worker worked till midnight, they have to be paid for that time. And sometimes we see violations for that reason. So how does a worker need to be paid for their regular time and their overtime? Well, for the regular time, the regular rate must be at least minimum wage, and that is $7.25 at the federal level. But then when you get to overtime, the basis of the overtime calculation is the regular rate, not just minimum wage. You can't have a situation where a worker has an hourly rate of 10 per hour, but then during overtime hours, the employer says, well, I'm just going to compute overtime based on $7.25, and they calculate time and a half of $7.25 or 1.5 times $7.25 to pay overtime. That would be a violation because overtime has to be paid with a basis on the regular rate of $10 per hour. So 10 times 1.5 is 15. 15 is the overtime rate in that case. But then sometimes you run into a situation where an employee may receive hourly pay plus something else, a commission or an earned bonus or piece rate pay. So, when it comes to determining a regular rate, if it's only hourly pay, it's very simple. The hourly rate, as long as it's more than minimum wage, is the regular rate. If there is no bonus, no commission, that's simple. But it gets more complicated when you have earned bonuses or commissions or piece rate thrown in along with hourly pay. And here's an example of that. So you've got one worker who is paid $10 per hour for 50 hours, but they also earned a $100 bonus. Let's say it's a production bonus that the employee earned for meeting a certain productivity goal or something. And the employee knew that if I do X, I'm going to get a $100 bonus. And the employee accomplished the goal, they get the bonus. And so their total compensation at straight time so far is $600. The $50 times 10, which is 500, of course, plus $100 in the bonus, that's $600 total compensation. So the way the employer would need to compute overtime based on the regular rate is down at the bottom of your screen. So you take the full $600 divided by 50 hours, and you get a regular rate of $12 an hour. That's the basis for overtime. You can't just go back to the $10 rate because that would be insufficient. That could cause an overtime violation. And we see this pretty frequently, actually. So with overtime based on $12 per hour, time and a half would be 18, of course. It's 1.5 times 12. But in this scenario, all the straight time has already been paid. In the calculation at the top of the screen, you can see all 50 hours, not just the first 40, but all 50 hours at 10 per hour, that's $500 plus $100 in the bonus, that's $600 total compensation. That's all the straight time paid, all 50 hours. So what's due now is only the additional halftime or the overtime premium for the 10 hours over 40. So you take those 10 hours, multiply them by half of 12, which is 6, of course, and 10 hours times 6, of course, is $60. So 60 plus 600, which has already been paid for straight time, is 660 total compensation for the week. That's what the employer would need to pay to be in compliance with the Fair Labor Standards Act. All right, moving on to another part of the Fair Labor Standards Act, and that's child labor. Like I said, we also call this youth employment sometimes. They mean the same thing. And these rules I'm going to cover today are about non-agricultural jobs. The rules are slightly different in agriculture, but for today's purposes, we're just going to talk about non-agricultural jobs. And there, the minimum age of employment is 14. So you can't have anyone 13 or less working in non-agricultural jobs. There are occupations restrictions, of course, for these kids 14 and 15 years old, but there are also hours limits, and I'll go through them on the next slide. So you have hours and occupations limits for those who are 14 or 15 years old. And the occupations limits go farther than what you'll find for 16 and 17-year-olds. 16 and 17-year-olds have 17 occupations that have been declared hazardous by the Secretary of Labor. And those same 17 hazardous occupations are prohibited for the 14 and 15-year-olds. But the occupations that are prohibited for 14 and 15-year-olds go even farther than that. So their work opportunities or what they're permitted to do on the job is restricted even more than what you'll find for 16 and 17-year-olds. There are some exceptions to these rules for minors who work for their parents if the parents are the owners of the business. So here you'll see the hours restrictions in non-agricultural jobs for the 14 and 15-year-old kids. They cannot work during any school hours. They cannot work more than 3 hours in a school day or more than 8 hours on a non-school day. And keep in mind that Friday is considered a school day, not a weekend day. So that's a mistake we see sometimes. Sometimes an employer may just assume, well, Friday is the start of the weekend, so this kid can work 4, 5, 6 hours. That's not the case. Friday is considered a school day, and so 3 hours is the maximum for a kid who's 14 or 15. And then 8 hours on a non-school day is the limit, and that would be your weekend days, Saturday, Sunday, or perhaps a summer day or a day during Christmas break when there is no school, things like that. Moving on, these kids at ages 14 and 15 cannot work more than 18 hours during school weeks or 40 hours during non-school weeks. Non-school weeks being, for example, in the summer, or if there's a full week during the winter holiday or Christmas break. A full week without school would mean that, the kid could work 40 hours that week. These kids at 14 and 15 cannot work before 7 a.m. at any time of year, and they can't work after 7 p.m. except from June 1st to Labor Day, when the evening time is extended until 9 p.m. So June 1 to Labor Day, that's where the law defines the summer, when kids can work a little later if they're 14 or 15. And then after Labor Day, the rule goes back to 7 p.m. So now we're in that Labor Day to June 1 period where the limit is 7 p.m. for 14 or 15-year-old kids. All right, so that's it for child labor. We'll move on now to a newer provision of the Fair Labor Standards Act. Like I said, the law has been around since 1938. So this provision on rest breaks for nursing mothers, it was an amendment to the Fair Labor Standards Act, and it came along with the Affordable Care Act, which was signed into law, I think, in 2010. So it's relatively new, but we have been enforcing it for a number of years now. And this is for nursing mothers for up to 1 year after the child's birth. They must be given reasonable break time to express breast milk, and the employer must provide a place other than a bathroom that can be used to express breast milk. All right, so that is it for the Fair Labor Standards Act. And now I'll go into the Family Medical Leave Act, which I think has been around since 1994. Most of you probably know it as FMLA. So this law basically has the following essential protections: 12 work weeks of unpaid leave per year for qualifying reasons. And we understand and appreciate the fact that many employers pay this time off in some way, shape, or form. There could be paid time off or PTO policy, vacation policy, sick time policy, or short-term disability that pays some or all of these weeks while an employee is on FMLA, and that's great. But at a minimum, FMLA leave would have to be at least unpaid and job protected for these workers. So they have job protection, they have the right to return to the same or an equivalent position when they get back from FMLA leave. And while they're on leave, their benefits must be protected and their status must be protected. Benefits, for example, health insurance. The employee is still responsible for their share of the health insurance premium, but the employer is required to maintain their health insurance benefits, for example, while they are on FMLA leave. Another law that we enforced and are still enforcing, to be honest, but it's a law that expired at the end of 2020. You may have heard a lot about it in 2020, the Family's First Coronavirus Response Act. It came into play near the beginning of the pandemic. It applied to leave taken between April 1st of 2020 and December 31st of 2020. And this law provided paid leave for COVID-19 related reasons. I say that we are still enforcing this law because if an employer failed to pay a worker as required, the worker may still file a complaint for up to 2 years. And so we're still in that period between December 31st of 2020 and December 31st of 2022, where complaints can still be filed. So employers who are subject to this law may want to make sure that they comply with it and paid all paid leave to workers who had COVID-19 related reasons for their leave, because workers can still file complaints for those violations up to 2 years after the violation occurred. All right, so that is it for FFCRA, and now I'll move into essential protections for agricultural workers. So these workers have a right to disclosure of their wages, safe transportation and housing, field sanitation requirements, and I'll explain what that is in a minute, and protection for H-2A non-immigrant workers. I mentioned earlier, we enforce the labor provisions under certain visa programs, one of which is H-2A, and that's for agriculture. The other visa programs where we enforce the labor provisions are H-1B and H-2B, which are not for agriculture. So when I said field sanitation requirements, I was referring to this second bullet point here: toilets, drinking water, and hand washing facilities for hand laborers in the field. This is something we check when we go on site for agricultural investigations. So employers must maintain these facilities, these field sanitation requirements for workers, hand laborers who are working in the field on their farms. Agricultural workers have a right to payment of a required minimum wage and minimum guaranteed hours for H-2A workers and the US workers who work alongside them. So there are some farms where part of the labor supply comes from the H-2A program, but some of the workers are US workers and they work alongside H-2A workers. They have these same rights. And then again, I just want to reiterate, these protections apply regardless of immigration status. So for all these laws I've talked about, all these regulations I've talked about today, if a worker or somebody else wants to file a complaint, how do they do that? So for the most part, lately, because of the pandemic, we've been taking these complaints by phone. And the coming months, hopefully we will be returning to the office. Looking forward to that. And we can also take complaints from third parties. So first and foremost, we get complaints from employees or former employees. Those are probably the majority of people who call us to file complaints, but we can also get complaints from third parties. And I'll show a list of who those third parties may be here in a moment. Complaints are confidential. We don't disclose the complainant's name. We don't disclose whether or not there is a complaint. I think I mentioned that earlier. In the course of our investigation, we don't discuss with an employer whether or not there is a complaint on a case. And there's no fee to file a complaint. What we do is a public service. Sometimes there's a misperception out there that somebody would need to pay a fee to file a complaint with us, and that is not true. As a federal agency, what we do is public service, so it doesn't cost anything to file a complaint with us. So who can file a complaint? Not just current and former employees, but parents or guardians or school officials, especially in the case of teenagers. If they are under the age of 18 and there are child labor questions, if a school official or a parent or guardian thinks that a kid might be working in a hazardous occupation, or they're working too late at night, too early in the morning, too many hours on a school day, violating any of those rules that I explained earlier, they can call and file complaints. Also, other employers, competitors, if, for example, just to go back to the restaurant example I mentioned earlier, if one restaurant owner or employer knows that the restaurant across the street is not paying minimum wage, not paying overtime, whatever the case may be, the competitor who is following the law and knows that there's another one who is not following the law, if the competitor following the law wants to, compete on a level playing field and do something to address the unfair competitive advantage that the competitor might be getting across the street, the employer can call and file a complaint, and we take complaints like that on a regular basis. Also, advocacy groups that represent workers or low-income communities and different advocacy groups that speak on behalf of workers, they file complaints. Also, other agencies at the state level, federal level, or local level, they may file complaints with us as well. So what sort of information do we look for when we get a complaint? All this information isn't required, but it does help us develop a case and determine whether or not an investigation is warranted. So you can see here the list of information, things you might expect, contact information from the employee and the employer, but also it's great to have any sort of written evidence, documented evidence, like copies of pay stubs, an employee's personal hours records if they are working off the clock or hours aren't being recorded or paid. Hours records are great to come along with that sort of complaint. All the information helps. So again, what you see on your screen isn't necessarily required, but it does help us develop a case. So in addition to these public presentations that we provide, we also have online resources for workers and employers and their representatives. In a lot of cases, there are workers that we just can't find. We try to contact workers as best we can. If we find back wages in a case where an employer maybe didn't pay minimum wage or overtime correctly, and there's a back wage check for a worker. But, since the time of employment with that employer, the employee may have moved and the employer doesn't have updated contact information, no phone number or address for us to use to contact the worker. And so those workers may be looking for their back wage check. And this website, you can see here, we call it the WOW program or WOW website. It stands for Workers Owed Wages. It's a place for workers to go and they can search the employer by name online and see if they might be owed a back wage check from one of our previous investigations. And this has worked to get a lot of workers their wages. And we're very happy to do that. We want we want these back wages in the hands of the workers who earned them, not sitting with us waiting for a place to go. Here I have a couple examples of websites that are very helpful and informative to workers and employers. Worker.gov, and you can see a picture of that on your screen that has an English and Spanish version. Employer.gov currently is in English, and I think maybe a Spanish version is in the works, but they're both very helpful and they provide the same kind of information, not just about wage and hour law that the Wage and Hour Division enforces, but other rules that are enforced elsewhere in the Department of Labor or the federal government. I mentioned earlier OSHA, Occupational Safety and Health Administration. They enforce safety and health rules in the workplace for all workers. And that kind of information is on this website as well. Also, information about anti-discrimination and the rights and protections of veterans in the workplace. That kind of information is on these websites as well. So it's really helpful to workers and employers. I would recommend that you check out both to see if there is information that you could be useful to you. All right, next, getting ready to finish up here, but here is my agency's website, the Wage and Hour Division website, dol.gov/agencies/WHD. It's also been on the bottom right of each slide during this presentation, and our toll-free number. Feel free to jot those down, but I believe these slides are going to be shared with you after today's presentation, so you will get a copy. So that is it for my presentation, and I think now there will be time for questions, but before I get to that, I got to show my favorite slide, which is the disclaimer, and says what I do is just my presentation is just a public service, but the true sources of information for the regulations we enforce are in the Federal Register and the Code of Federal Regulations. With that being said, I hope what I did say today was informative and helpful to you, whether you are an employer, accountant, attorney, or a worker. Hope that you learned something. And if there's anything that's, still you're still questioning in your mind, I'd be happy to take any questions you have now.
Thank you so much, Colin. Right now, I don't see anything in the chat box, but you certainly have an opportunity, everyone, to submit your questions. Just want to wait a few seconds or minutes to see what we have here. So far, we don't have any, but I just want to invite everyone to still submit your questions. You have Colin's direct information, and we'll share that with you as well if you think of anything after the presentation. But thank you so much for educating our attendees and me today, being a resource for our South Carolina business owners. And to everyone listening, you now have a direct line to get your labor and wage questions answered. So please make sure that you take advantage of the opportunity, and with anything that you have, you can certainly reach out. There is one question coming from Wallace Evans, and it says, has the DOL determined how FLSA impacts nonprofits?
Sure, great question. Thank you, Wallace, for the question. So there are some rules on how the Fair Labor Standards Act impacts nonprofits. There are some resources I can send to you, sir. If you wouldn't mind, you could put your email address in the chat there, or you can email me directly. I'll put my email address in the chat box too. All right, so there are some publicly available resources I can share. The Fair Labor Standards Act wouldn't necessarily apply to all nonprofits or all workers who work for nonprofits. There are some rules about volunteers or churches. And then you get to the case of really small nonprofits that might not be covered under the Fair Labor Standards Act. There's this concept of coverage where we have two different ways to cover workers under the law and make sure that minimum wage and overtime apply to those workers. There's something called enterprise coverage, where if the organization has $500,000 or more in annual sales or revenues, and there are workers involved or participating in interstate commerce, then the law would apply to the whole enterprise. All workers in the enterprise would be eligible for minimum wage or overtime unless they're exempt. And exemptions often pertain to executive, administrative, or professional employees, higher level, white collar employees who earn a salary. But so first is the concept of enterprise coverage. Is the business or the organization large enough? Do they have that $500,000 annual sales or revenues for the FLSA to kick in? Do they have some sort of participation or involvement in interstate commerce? And that could be something as simple as, office supplies coming from out of state or out of the country. That would be enough evidence of interstate commerce. If employees are using those things on the job and the business is big enough in terms of sales or revenues, then that would make the FLSA kick in for coverage. There's also the concept of individual coverage, where even if the employer is too small, let's say their annual sales or revenues are below $500,000, but there's a worker who is directly participating or involved in interstate commerce. Let's say it's somebody who calls, emails, faxes documents across state lines, or they travel across state lines in the course of their work. That is direct participation in interstate commerce, and that person, regardless of the size of the business, could be covered by the Fair Labor Standards Act and therefore eligible for minimum wage and overtime protections. But again, there are volunteers sometimes who may not be considered employees eligible for minimum wage and overtime under the law. There are certain organizations such as churches that may not have FLSA apply. So I guess that's sort of a general answer. It may not answer directly your question. So again, please email me if you have more specific questions. And I got your email address there. I can send you some of those publicly available resources. Thank you.
Thank you. We have one more question in the chat box, and that may be more directed for me. How do we sign up for additional webinars in the series? And that comes from Sharon Hammonds. Sharon, we have one more webinar left that's coming up in December, and that one will feature Apprenticeship Carolina. And we will send a link out along with the information today, so you can sign up for that. Just to everyone online right now, there is a holding space for all of the webinars that we had in the series on our YouTube channel. So I'll definitely send the link out for that so you can see past webinars as well and all the other resources that have been shared today. Let's see. I don't see any other questions popping up right now. So it looks like you did an outstanding job, Colin, with presenting all the information and sharing all the details that's needed. And just want to thank you once again for presenting today. Since we are talking about wages, I'd like to direct everyone's attention to Size Up SC on our Commerce website. And on this one right here, hold on one second, you'll see that Size Up SC logo. This is a great business resource tool that we offer to everyone. There's no password or login information needed. And there you can find it on our website, which is scbizdev.scommerce.com. If you didn't catch it, don't worry about it. I will send it to you along with everything else that we have. But there, using that platform, you can enter your industry and your location to review many different sections of the platform. There's a section about marketing, advertising, finding your customers, finding your suppliers, and a lot more information there as well. You can also enter the annual salary that you're paying your employees to see how your company sizes up with others like it in your city, in your county, in the state and nationally. You can see if you're paying at rate, above or below average for that particular job and how you pay your employees. So it's a great resource. So it's a great business tool, and I invite you to take a look at Size Up SC on our website. Like I said before, there are no passwords, it's user-friendly, and it's easy access to big data to help you support your business decisions that you have to make. So I will send that to you. Also on this slide, you'll see our Source SC logo. So if you're not familiar with Source SC, that is our commerce database that we use when companies, all size companies, large, small, and anything in between, they will contact Commerce looking to connect with South Carolina business resources, whether they need a widget for manufacturing or a particular service. There's no limits to what they can ask for as being a Source SC member and when those companies call us. So Source SC is the #1 place we go to when we're looking for that. So if you would like to make sure that your company has its name in the hat and name in the number, so to speak, when we provide those listings to those companies to make those connections, please go there as well to register your company. It is a free of charge service, and we will work on your behalf as well. So in the event that you would need to connect with certain companies or you need a particular widget or service and you really don't know where to go, I'm not sure if you're looking for something in a particular county, we here at Commerce would do the legwork for you and help and look through that. But Source SC is our main database where we get all of that information. Lastly, I'd like to draw your attention to our BizFeed logo at the bottom. That's something new that we have in our Business Services division here at Commerce, and it's our newsletter where you can find out about more events like this one today and other upcoming conferences and special information to help you develop your business. There's an opt-in option that I will send out to everyone if you would like to be on the Commerce email address for this particular newsletter that'll be dedicated to business development. On the next slide, I'm sorry, before we go to the next slide, I just want to see we had Dayton's information up there. I'm sorry, Dayton is our supplier outreach program manager, and he manages the Source SC platform. So you see his contact information there as well. So if you had any particular questions, if you wanted to know more about that program, or if you need some direction to navigate through the registration process, please make sure you reach out to Dayton or myself, and we'll be able to help you navigate through that. So now I'm ready for the next slide, where we'll see our next event for next month. We're going to feature Apprenticeship Carolina, and that would be on December 8th. And there too, you can see where you can register. The email address is there where you can register, and I'll provide that as well with all the other information that you're going to get at the end of today's webinar. So I think that's about it. I checked the chat box once again, just to make one last look to make sure we have everything covered. If there are any questions left, so far we don't, but to everyone on the webinar today, you have plenty of contact information where you can reach out to Commerce. You can reach out to me if you need to get in touch with Colin and missed his information, and vice versa. If he has anything that he would like to share, make sure he can reach out to me as well. But we want to thank you all for joining us today, and make sure that you look out for the survey that'll be coming to you soon. And thank you so much. And thank you again, Colin, for joining us and presenting for us. And that concludes our webinar for today. Have a great week, everyone. Thank you.
Thank you, Sonia.
All righty.